Perfect. All right, well, good morning, everyone, and welcome to the final Chamber Education series of the year. My name is Ann Tuma. I'm the Vice President of Programs and Development for the Hampton Roads Chamber. I want to thank Steve Gerald and Josh Stiff today for being with us to talk about maximizing recoveries and minimizing risk when doing business with a distressed customer. So Steve focused his practice on corporate bankruptcy, business restructurings, and related matters in the distressed debt space. He represents debtors, official committees, individual creditors, and other parties in interest in Chapter 11 and Chapter 7 bankruptcy cases. Josh Stiff's practice focuses on commercial litigation, bankruptcy, and creditors' rights, with an emphasis on representing debtors, creditors' committees, trustees, and other parties in complex liquidations, restructuring, workouts, distressed asset transitions, and other insolvency-related matters. So I want to thank Josh and Steve today for being with us to talk about this important subject. They will go through their presentation. If you do have any questions, please enter them into the Q&A box at the bottom. Leanna will be monitoring that Q&A box, and we will answer questions. If it's an urgent question, we'll answer it as the presentation is going along, but we will try and hold off till the end to answer most of them. So with that, I'm going to turn it over to Steve and Josh.
All right. Good morning, everyone. I guess before we get started, we'll acknowledge the hospitality sponsor, Hercules Fence, security in every job. Thank you, Hercules. Just before we get started, and thank you, Ann, for the very kind introduction. Whiteford, Taylor, and Preston is a law firm of about 180 lawyers, Mid-Atlantic, footprint, and 17 offices serving all of the business needs of companies, both for litigation and transactional work. Josh and I specialize in the distressed debt space. So today's presentation, we're going to talk about maximizing recoveries on debts that are owed by customers, minimizing risk from affirmative claims by customers, both during and prior to a customer's bankruptcy case. Now, first, we'll talk about pre-bankruptcy protection. One of the first things that we like to tell our clients is that you really need to know who your customer is and do as much diligence as you can before extending credit to them. Some of the things that you may want to look into before extending credit to a customer: take a look at their corporate organization, see what potential guarantors there are, what other affiliates the company may have, subsidiaries or affiliates that whose assets may be cross-collateralized. Take a look at the capital structure, amounts owed and available credit, due dates. A lot of that information is available online and publicly. The amount of trade that they're carrying, and then other public filings such as SEC filings and other reporting. Other things to do that you can look at: trade and bank references. There are various types of reporting, as I mentioned. For example, done in Bradstreet, that can give information about a company's credit information, and then other organizations: Debtwire, Reorg, Bloomberg, and then maybe some resources that may be specific to an industry to know how your customer is doing financially. There are certain warning signs for distress that folks should be aware of when dealing with a company and extending terms to those folks. Dishonored checks, post-dated checks, these all indicate stress. Changing payment patterns, if they're delaying payment or even expediting payment. Changing the payment of method. One thing that's common is folks are, paying by check, and then all of a sudden they start, wiring payments that may be a sign of distress. Obvious signs like store closings, differences in stock levels, and of course, the two real big ones, change in the executive team may indicate some kind of distress, particularly if that leader in the executive team is someone that's involved in the insolvency industry. And then, of course, retention of insolvency counsel, which may or not be public information, but sometimes it is. The big thing, just talk to others in your industry, because I always recommend that. Talk to the counterparts in your industry, and it's always helpful to share that information. In terms of protecting before bankruptcy is filed, I think the best thing that one can do is pretty obvious: get payment in advance, and that avoids the whole issue of extending terms. It's not always possible, but recommended, and it minimizes exposure, not just from lack of payment, but as we'll talk about later on in the presentation, it can minimize exposure from affirmative claims in a future potential bankruptcy filing. So a little hypothetical here, just to kind of keep it a little interactive. Buyer has 30-day terms and has been consistently late to pay. Seller has unpaid invoices and unfilled purchase orders. Just before shipping product on terms, seller obtains information that buyer is in financial distress. What can seller do? Okay, there is something called the right of adequate assurance of performance. And what that is it's something that's set forth typically in a statute. There's a statute, a uniform statute called the Uniform Commercial Code. Just about every state has adopted its own version of the Uniform Commercial Code, and their respective courts are interpreting their particular Uniform Commercial Code. But we're going to go through kind of just standard provisions of the Uniform Commercial Code that may be applicable. In this case, right to adequate assurance of performance. So if there are reasonable grounds for insecurity, and those are based on commercial standards, you can demand in writing that your customer provide adequate assurance of due performance. And until that assurance is received, you may, and this is again subjective standards, commercially reasonable, you can suspend performance. Failure to provide assurance within a reasonable time, again, a subjective standard, not exceeding 30 days, is a repudiation of the contract, relieving seller of its obligations. This can enable you to change your payment terms, shorten terms, require payment in advance. This is the seller's ability to terminate the contract or change terms before the buyer files for bankruptcy. As we'll see later when we talk about bankruptcy, you lose that ability. And I've been in situations where we changed terms to prepay on the eve of a bankruptcy filing. And in that bankruptcy case, we then had payment in advance terms, which was extremely advantageous to the client. Grounds for insecurity, i.e. the basis for taking action, we recommend that it be the current factors that are causing distress and not anything that's based on outstanding AR, because as we'll see, it could be interpreted as pressure to pay, which is a factor in some type of litigation that a bankrupt entity in bankruptcy can take against its creditors. And so we want to avoid that, but we'll talk about that a little later in the presentation. Types of adequate assurance performance, kind of the obvious ones: letter of credit, bond, guarantee, security deposit. And these are just ways to kind of just ensure that you're going to get paid. Point of this kind of part of the presentation is just to exercise your rights. And it's important that you exercise your rights at the right time, particularly before bankruptcy files. One more hypothetical, another hypothetical, I should say. Buyer orders product from seller. 2 days after buyer receives the product, seller learns that buyer is financially distressed. What can seller do? All right, the seller can seek to reclaim goods. That's a legal term of art, reclaim goods, if it discovers that buyer received goods on credit while insolvent. Right to reclaim goods subject to the rights of a buyer in the ordinary course or other good faith purchaser. So what that basically means is that you have the right to reclaim goods, or you have the right to require them to put the goods aside and hold them for you. But those rights may be subject to the rights of a buyer in the ordinary course. It's just a regular sale if those goods have already been sold to a third party. How long do you have to send your reclamation letter after the buyer receives the goods? 10 days, not a lot of time. We'll talk about bankruptcy reclamation. It's 20 days. But outside of a bankruptcy case, you have 10 days, not a lot of time. However, if there is a misrepresentation of solvency to you in writing within 3 months before the delivery, that 10-day limitation does not apply. Last hypothetical. Buyer orders product from sellers. Seller makes arrangements with XYZ shipping company to ship the product to ABC. While the goods are in transit and in the custody of XYZ, seller learns that buyer is financially distressed. What can seller do? Well, again, this is another UCC provision. Law may be different depending what state we're talking about, but generally speaking, the seller may stop in certain circumstances delivery in the possession of a carrier or their bailee when it discovers buyer to be insolvent, or when buyer fails to make a payment due before delivery. What if the goods are in transit when your customer files for bankruptcy? Well, the primary issue is whether title has passed to buyer under the documents or applicable law. So, pre-bankruptcy protection. Take affirmative steps to ensure that you maximize your ability to collect on open accounts and protect your product. And while statutes like the ones we've discussed provide default guidelines, typically parties can contract around statutory protection. And so it's very important that when you're dealing with customers and you think they may be distressed, you really should have contracts that kind of set forth what the rights of the parties are. Contractual issues to be mindful of. Ability to modify or terminate the contract. You can typically do this pre-bankruptcy, but as Josh will talk about in the bankruptcy scenario, you really can't do that post-bankruptcy. So it's important that you have the ability to do it pre-bankruptcy. This is not something that would be statutory, and it's important that you have the ability and you exercise those rights at the right time. Ability to set off amounts due and owing, and that just basically means you owe them, they owe you, and you have the ability to offset those amounts. And then determining what the receipt date is for goods versus the transfer of title and risk of loss. Sometimes they can be two completely different things. And it's important to note when title transfers, because that'll play a big role in a bankruptcy case. And then, of course, the termination date of the contract, which is important as contracts play a big role in bankruptcy, as Josh will talk about. Short of obtaining payment advance, the second best, or I should say the best position to be in is that of a secured creditor, where you actually you get a lien on assets, you've got collateral, you have priority over unsecured creditors, and depending on when you perfect your security interest, you have priority over other secured creditors. This is the maximum protection that you can obtain. And it provides a predictable system of creditor priorities. I know we're in Virginia, but I'm a Maryland boy, so go Ravens. And maximizing risk pre-bankruptcy. This is sort of additional defensive steps that you can take to minimize your risk. And when we talk about minimizing risk from affirmative claims by a bankruptcy debtor, while this is a bankruptcy kind of topic, these are things that you can do pre-bankruptcy. And what we're talking about here, we've got the petition date, which is when the company files for bankruptcy. Post-bankruptcy is kind of everything that happens after the company files for bankruptcy. Pre-bankruptcy is obviously everything that occurs pre-bankruptcy. The time that we're most concerned about is this 90-day period. That's your danger zone. That's what we need to worry about. Some of you may have been on the receiving end of a preference action. And what that is, the elements of a preference action. The bankrupt company seeks to recover transfer of an interest to or for the benefit of a creditor within 90 days before the bankruptcy filing on account of an antecedent debt made while the buyer is insolvent. And it enables the seller to obtain more than it would in a Chapter 7 liquidation. Now, I prosecute these, I defend these, and admittedly, this is probably one of the most unfair aspects of the bankruptcy code. It's fair in the respect that in the intent of it is to bring in all the money that was transferred subject to certain defenses, transferred within 90 days to avoid bankrupt entities from preferring certain creditors over others. And so it brings it all in, makes a pro rata distribution to all the creditors. But it's unfair when you're on the receiving end of one of these things, because you could be owed any amount of money in the bankruptcy on account of unpaid invoices. And then all of a sudden you get sued for money that you received within 90 days. So, but it has the force of any other litigation. You get sued for one of these and you ignore it and a judgment gets entered. It's just like any other action, any other judgment where an entity can enforce its judgment on your assets. What can be considered a preference? Well, payments or other transfer of an interest in property. So any kind of transfer. It can be obtaining a security interest or a lien within that 90-day period. It can be effectuating a set-off within that 90-day period. But at the end of the day, what I don't want to convey is that you shouldn't take the money, because at the end of the day, cash is king, right? I'd rather have the money in hand and defend a preference action where I may or may not have defenses, or I may or may not be able to attack their case in chief, than never have the money at all. So I would take the money and deal with it after the fact. Now, minimizing risk pre-bankruptcy further. Okay, so when we're talking about a preference action, how can you minimize your risk? What's in your control? Certain things are in your control, certain things aren't. All right. Transfer of an interest to you, i.e. payment or some transfer of assets. You can't control what someone does if they're going to transfer something to you. To or for the benefit of the creditor. Well, at that point, you're a creditor. Can't do much about that. That's kind of after the fact. And within the 90 days, can't really control that. Okay, so this is typically out of your control. But we want to be careful about exerting pressure to pay, which we'll talk about. On account of an antecedent debt, can you control that? Yeah, you can require payment in advance. Made while the debtor is insolvent, can't really control that. The statute presumes that the debtor is insolvent, but it gives you the opportunity to rebut that presumption, although that can be a pretty high burden and a pretty expensive one, because you have to try to figure out, was this company truly insolvent or rendered insolvent by the payment? Enables the creditor to obtain more than it would in a Chapter 7 liquidation. Well, the only way you can really protect against that is to be a secured creditor, because you would have obtained the same recovery in a Chapter 7 and thus would not have gotten a better result outside of a 7. Now, so going back to this, there are ways to attack the debtor's chief case against you by kind of like focusing on these things. But there are also defenses that you can raise to a potential preference action. The first one is called the ordinary course of business defense. And essentially, the elements of that you have to have a debt that was incurred in the ordinary course of business. So essentially, just a normal debt, it's incurred just like any other debt was incurred. And one of these two, made in the ordinary course of business, which is a subjective standard, or made according to ordinary business terms, which is an objective standard. Now, before the bankruptcy law was changed in 2005, a preference defendant, someone that received a preference payment, would have to prove all three of these. But now, you just have to prove that the debt was incurred in the ordinary course of business and one of these two. Now, let's talk about the objective standard first. It's basically looking at industry standard. And there are, I guess, the most common way to prove industry standard. There are certain reference guides that provide data based on industry. And so essentially what you would do is, if you don't know already, you'd figure out what your NAICS code is. And NAICS, has numerous codes based on your industry. And then there's data. And one of the data points that they track typically is days to pay. And they'll look at that within time periods by year. They'll look at that by amounts that were paid or amounts of the company's revenue. And so you would essentially try to compare the days to pay. How long did it take the company to make these payments from invoice date to payment date, and compare that to what is standard in the industry. The other way is through expert testimony. And typically you would do that. That could be kind of a pricey venture. If you couldn't find the NAICS code, or if the NAICS code isn't helpful and you're confident that it's nonetheless within your industry. But like I said, that could be an expensive venture, but some of these preference actions can be pretty high in value as well. And so you got to do a cost benefit analysis. I mean, I've defended and prosecuted preference actions in 7 figures, all the way down to statutory minimum to keep it in a certain jurisdiction, which is around 13,000, but it goes up every year. All right, so the tip, try to be familiar with the industry standard and try to keep your payments in compliance. Now, the subjective standard, this is the other way that you can prove that the payments were made in the ordinary course of business. And what that does, it compares how the payments were made during this insolvency period to how payments were made before the insolvency period. But typically what you're looking at the payments that were made in that 90-day period, the preference period, the ones that the debtor is trying to recover, and then looking at a historical period. And so you'd look at days to pay. How long did it take them to pay? So you're looking at timing of payments. And typically what you do is you look at, like I said, what was your invoice date and when was it due? And then you compare days to pay to your historical period. And, depending on the jurisdiction, there are different things that you look at. Sometimes you look at range of payments. Sometimes you look at average. You may look at standard deviation. But depending on where you are, there could be different standards as to what is ordinary. You look at the method of payment, which is something that we talked about earlier, in determining whether there's distress. If a payment was made historically by check, and then all of a sudden payments are made by wire in that 90-day period, that may be something that may cause a payment to be outside of the ordinary course of business. So from this perspective, from your perspective as a potential defendant in one of these actions, you would want to show that the timing is the same, the method of payment is the same. You also want to be cognizant of the number of invoices that were paid. A lot of times you'll see batch payments. You'll see one payment, satisfies, 10 invoices, for instance. So, you'll want to see, you want to compare that, the payments that were made during that 90-day period, and you want to compare it to the historical data. Did you have a situation where historically it was, one payment for one invoice, and then all of a sudden, it's one payment for 20 invoices? That could be something that could bring a payment outside of the ordinary course of business, and thus make you potentially liable for returning that payment. Pressure to pay. We've talked about pressure to pay. You've heard that term a couple times now, and I said we would talk about it. So unusual pressure to pay, what is it? So typically it's collection efforts that are not within the party's ordinary course of business. And so what you're trying to show here in showing that your payments were made in the ordinary course of business is that it's just ordinary. It's how it was always done. And so, if all of a sudden you're pressuring to pay during that 90-day period and calling and numerous calls, hey, I need you to pay, you haven't paid. Hey, I'm not going to ship goods until you pay. That could be problematic. But the pressure to pay typically needs to be the cause of the payment, right? There's got to be some causal link between the pressure and the actual payment. And if the payment was otherwise going to be made, one could argue that it was not the result of pressure. The prime example is conditioning future shipments on payment of unpaid invoices. And I've had a case where I was defending one of these things. Company was sued for preference, and the payments looked very ordinary. You know, we were comparing the preference payments to the historical period, very ordinary. But we found, you know, in discovery, there were emails. I will not ship unless you pay these old invoices. And it was a dead loser for us. So there's got to be a delicate balance between proactive collection and pressure to pay. So you need to balance at the end of the day, receiving no payment at all and no preference risk against obtaining payment and having the future preference risk, you know, plus legal fees. How do you collect without pressuring to pay? Well, you know, some things to do in terms of just trying to argue the ordinary course, you know, keep collection practices consistent. Try to have a manual. I recommend putting together a written manual so you can say, hey, this is how we do it. It's you know, it's ordinary. We've always done this, you know, avoid exerting leverage to compel payment, like the example that I gave. You know, if you don't pay, you know, we're not going to continue to ship. And the biggest thing, you know, focus on current stress indicators. So, you know, if I'm going to send a letter and say, you know, we're not going to ship any longer, or we're not going to extend credit any longer, it's not necessarily because, although it may be in reality, because they haven't paid these old invoices. But what I'm focusing on is the current situation. You know, we're worried about your current status. We're worried about your current distress. That's what the focus should be on. Second defense, contemporaneous exchange of new value. What is it? It's intended by the debtor and the creditor to be a contemporaneous exchange for new value given to the debtor. And in fact, it was a substantially contemporaneous exchange. And what that basically means, I mean, the biggest thing that you can think of is like COD, or payment like almost immediately thereafter. So how can you be proactive in a contemporaneous exchange of new value defense? Like I said, cash on delivery or very prompt payment. There's one last defense that I want to talk about. It's called the subsequent new value defense. And it's after the actionable transfer. So you receive a transfer in the 90-day preference period. That is potentially a preference payment. And then thereafter, you give new value. So you provide new goods or new services to or for the benefit of the debtor, the company that filed for bankruptcy. It's not secured by an otherwise unavoidable security interest. And it's on account of which new value the debtor did not make an otherwise unavoidable transfer to or for the benefit of the creditor. Kind of two legal terms, but at the end of the day, what we're looking for here essentially is you provided new goods, new services, some limitations that, you know, some nuances. Good example. January 1, buyer makes payment to seller $10,000. So that $10,000, this is potentially recoverable, depending on defenses. January 2, new values provided. New goods, new services. It brings down the amount to $5,000. But a different example is, let's do this. Let's do this. January 1, preference payment of $10,000. January 2, $15,000 in new value. You don't get like a $5,000 credit here. That brings your new value down to zero. So if you then make another $5,000 payment after that, you've got $5,000 in liability. So it's formulaic. It's not just, you know, sort of offsetting one against the other. Usually new value can be paid or unpaid. Some courts require that new value remain unpaid. Subsequent new value defense, how can you be proactive? Well, it's sort of a catch-22 because, you know, you provide new value, sure. You might be minimizing your preference exposure, but on the other hand, you might be increasing your exposure of non-payment. So it's kind of a tricky thing. All right, so now we get to filing for bankruptcy. I'm going to turn this over to Josh. Josh, you tell me when you'd like me to switch the slides. He's going to talk about issues that come up in the bankruptcy case.
Thank you. So Steve has reviewed tips for how to approach an insolvent debtor prior to filing a bankruptcy, and I will now spend some time reviewing the basic information and tips that you need to consider when dealing with a debtor that is actually filed for bankruptcy. Before we begin, I would like to raise one important point. The word bankruptcy, particularly in commercial contexts, often elicits a dismissive response from businesses. And I would say, please do not be taken with such pejorative connotations of bankruptcy. Commercial bankruptcies are purposed to preserve and maximize value for all parties, especially creditors. And if a company with whom you do business files for bankruptcy, do not make the assumption that you're facing a loss proposition. There is value to be gained and extracted in bankruptcy. However, you must take action in the bankruptcy to preserve and protect your rights and your entitlements to a recovery. So what a bankruptcy is and how it operates can depend on a number of factors, such as the type of debtor, specifically whether the debtor is an individual versus a business entity. It can further depend on the nature of the assets and the liabilities, such as whether they are primarily consumer or commercial in nature. And lastly, what is going to happen to the assets heavily influences the proceeding. Will the assets be sold and liquidated, or will the business retain its assets and attempt a reorganization? The relief and rules governing can differ based on these considerations. However, our presentation will focus on commercial bankruptcies, or in other words, bankruptcies involving businesses. When a debtor files for bankruptcy, it must select a chapter under which to file. While these chapters share certain principles and rules, they contain differing processes to accomplish different purposes. You may have heard of a Chapter 7 bankruptcy, which is known as a liquidation. Individuals and business entities may file for Chapter 7 regardless of the nature of their debt. In a Chapter 7, a trustee is appointed over the case, and it is the trustee's job to review the debtor's assets and liquidate any property of value in order to take that money and make a distribution to creditors. Once the Chapter 7 bankruptcy is filed, it is typically controlled by the trustee, not the debtor. And generally speaking, a business that files for Chapter 7 does not continue operating after the bankruptcy filing. Creditors can participate in the process. However, they usually only do so if either there are assets to liquidate and distributions from the trustee are expected, or if the creditor has an interest in the debtor's property and needs to take steps to enforce its rights against that property. You may have also heard of a Chapter 11 bankruptcy, which is known as a reorganization. Individuals and business entities may file regardless of the nature of their debt, although different rules may apply to consumer debts. In a Chapter 11, the debtor typically retains assets and proposes a plan of reorganization to its creditors. Generally speaking, a trustee is not appointed in the case, and the company controls the course of the bankruptcy. The proposed plan must be confirmed by the court before it goes into effect. However, once confirmed, this plan represents a new contract between the debtor and its creditors. Typically, the debtor continues to operate its business during the bankruptcy. However, it must retain what is called administrative solvency during the proceedings. In other words, it has to maintain an ability to pay its operating expenses during the course of the case. There are other bankruptcy chapters, such as Chapter 13, which is an individual repayment plan, and Chapter 12, which is a reorganization for family farmers and fishermen. However, we will not address these today, and instead we'll focus on Chapter 7 and Chapter 11. Steve, could we move to the next slide? So once a bankruptcy is filed, the automatic stay goes into effect. The automatic stay is an injunction that enjoins all creditors from taking any action to collect on or enforce their pre-petition claims or liens against either the debtor or the debtor's property. The stay automatically goes into effect upon the filing of the bankruptcy, which means creditors cannot take any action after the filing to collect, cannot take any collection activity after the bankruptcy filing occurs unless they are expressly authorized by the bankruptcy code or the bankruptcy court. The automatic stay is very broadly interpreted by the courts. It includes any action to collect on a debt against the debtor, such as making collection calls to the debtor or its representatives. It includes commencing or continuing a lawsuit, including obtaining or enforcing a judgment against the debtor or the debtor's property. This is not limited to claims just based on the debt. The stay equally applies to all manner of civil actions, including proceedings in tort, contract, or equity, whether filed in federal court or state court. The stay also enjoins any act to obtain or enforce a lien or security interest against the debtor or its property, such as foreclosures, repossessions, levies, garnishments, or any other activity to take possession of the debtor's property. If you remember anything from this presentation, please remember that once you are aware that a bankruptcy is filed, take no further action to recover on your claim unless you go through the proper bankruptcy process. The standard for violating the stay is very low. The offending party need only know of the existence of the bankruptcy case and take an action that is found to have violated the stay. The consequences for violating the stay can be severe. The violator can be held in contempt of court and subject to sanctions and assessed actual and punitive damages, including costs and attorney's fees. I've seen instances where the actual damages for a stay violation are less than $500, but the offending creditor was stuck paying the debtor's attorney fee bill of $20,000 to $30,000. If you are ever dealing with a customer or other party subject to the automatic stay, please contact a bankruptcy practitioner before taking any action. And if there's ever a question of whether the stay applies, still do so. When it comes to the automatic stay, it is always better to be safe than sorry. Steve, can we go to the next slide? So I'd like to transition now to talking about avenues for recovery in a bankruptcy case. The first of which, can we go to the next slide, Steve? The first of which is executory contracts and unexpired leases. So debtors in bankruptcy, like all businesses, can be party to all manner of contracts, such as master agreements, purchase orders, consulting agreements, commercial leases, equipment rental agreements, etc. Since the debtor has an interest in these contracts, they are considered property of the bankruptcy. And as such, the non-debtor counterparties to these contracts need to be aware of their rights and applicable rules. Steve, can we go to the next slide? First, contracts often include provisions that allow the contract to be modified or terminated upon the debtor's insolvency or filing a bankruptcy. These provisions are known as ipso facto clauses, and they are unenforceable in bankruptcy. Can we go to the next slide? Not all contracts are treated the same in bankruptcy, and a primary distinction is whether the contract is executory. An executory contract is one where there are material unfulfilled obligations on both sides of the contract. In other words, the executory contract is a two-sided agreement. Take, for instance, a promissory note. While there are two parties to this contract, once the lender has loaned the debtor money, it is a one-sided contract. The debtor is obligated to repay the loan. The lender otherwise has no obligation to the debtor. This is not an executory contract. An executory contract would be, for instance, an exclusive supplier contract. In such a contract, the supplier is obligated to sell goods to the buyer on an ongoing basis, and the buyer is similarly obligated to buy goods from the supplier on an ongoing basis. This is a two-sided agreement where both sides have continuing obligations to the other. Executory contracts hold a special status in bankruptcy as they are both an asset and a liability of the debtor. The debtor's rights under the contract are considered an asset, while the debtor's obligations are considered a liability. For the same reason, the counterparty, the non-debtor counterparty, is also considered a creditor and obligor in the bankruptcy case. On the obligor side, the counterparty is obligated to continue performing on the executory contract during the bankruptcy case. The obligation to perform does not continue forever, but it is important to continue performance until the contract has been assumed or rejected by the debtor. We'll discuss assumption and rejection shortly. However, the important point here is that the failure to perform can constitute a violation of the automatic stay. Can we jump to the next slide? And let's go to the next one after that. So since an executory contract is both an asset and a liability, the trustee or the debtor must choose whether to assume or reject the contract. If the contract is assumed, the debtor binds itself to the terms of the contract, with the debtor preserving all rights and benefits under the contract while also remaining subject to all burdens and obligations. To assume the executory contract, the debtor must cure all defaults under the contract as of the time of assumption. It may also be required to provide adequate assurance of future performance. And lastly, the contract must be assumed what is called cum onere, or without changing any of the terms of the contract. For those fortunate enough to be party to an assumed contract, this is an opportunity to be made whole, because the debtor must cure all defaults under the contract at the time of assumption. Can we jump to the next slide, Steve? If the debtor chooses to reject the contract, the bankruptcy estate is no longer bound to the terms of the contract. While the debtor is no longer subject to the burdens and obligations, it is also no longer entitled to the rights and benefits of the same. When rejected, the contract is treated as if a material breach occurred immediately prior to the bankruptcy filing, and the non-debtor counterparty is entitled to a claim for such breach. Can we jump to the next slide, please? Steve previously touched on secured claims. The important point I want to raise is that bankruptcy does not alter valid, perfected property rights of non-debtor parties in debtor property that exist as of the bankruptcy filing. These are referred to as secured claims in bankruptcy parlance. So if a creditor holds a valid and properly perfected lien against collateral when the debtor files for bankruptcy, such secured claim will maintain its priority interest in the collateral. It will survive the bankruptcy process, and any disposition of the collateral in bankruptcy is subject to satisfying the value of the secured claim according to its priority position. Steve, let's jump to can we jump to the 503b9 claim slide? Perfect. So certain claims in bankruptcy are entitled to priority payment status. An example thereof are what is called Section 503b9 claims. These are claims for the value of goods received by the debtor in the ordinary course of business within 20 days prior to the bankruptcy filing. These claims are entitled to what is called administrative expense priority. This priority treatment does not guarantee payment. It just ensures payment in full on these claims prior to payment on any junior priority claims in the case. Can we jump to the administrative expense priority? Perfect. So the debtor following a bankruptcy filing will often continue to operate the business and purchase goods and services. If these goods and services acquired after the bankruptcy filing are purchased on terms, the debts are known as administrative expenses. These administrative expenses are entitled to priority treatment, which again means that these expenses get paid before any other claims in the case. The administrative expense priority provided by the bankruptcy process is purposed to incentivize parties to continue conducting post-petition business with the debtor during the case. And in a Chapter 11 case, the debtor must pay administrative expenses in full in the ordinary course in order to proceed with its reorganization. When considered transacting business with a Chapter 11 debtor, you should consider all the normal risk factors involved with an insolvent party. However, keep in mind that the bankruptcy process is a transparent process. The debtor is required to file financial statements with the court, which you can use to assess and monitor the creditworthiness of the post-petition transactions you may be conducting with the debtor. Steve, can we jump to the critical? Perfect. Some debtors in Chapter 11 offer what's called critical vendor agreements to certain vendors. These agreements generally entail the debtor offering to pay or accord priority treatment to a vendor's pre-petition claims in exchange for their vendor agreeing to continue providing post-petition goods and services on terms. Critical vendor agreements only exist in Chapter 11 cases where the debtor has obtained approval from the bankruptcy court to employ such a program and has funding for the same. Critical vendor agreements are a great opportunity to maximize recoveries on your claims in a bankruptcy case. However, creditors pursuing and negotiating such critical vendor agreements need to tread carefully so as to not violate the automatic stay, since you are negotiating a payment of a pre-petition debt. And with that, that concludes our presentation, and we'll take any questions that anyone might have. Thank you.
Thank you, Josh. Thank you, Steve. Does anyone have any questions for them? If you do, just type them into the Q&A box and they will answer them for you. Any questions? Well, I think you did such a thorough job explaining everything that no one must have any questions for you. Steve and Josh, thank you again for explaining this important subject to our members. Just so everyone knows, this will be posted on our YouTube page, so you can go back and watch it if you want to take another look at the slides. And that concludes our final chamber education presentation for 2023. We will be sending out a request for presenters for 2022, it finishes. We'll be doing requests for presenters for 2023. So please let us know if you're interested. We are looking to go back to in-person for these events. So again, if you are interested, please reach out to me or Leanna. And that concludes our final event of 2022. Steve and Josh, thanks again. And I hope everyone has a great day.
Thanks, everyone.
Thank you.